Honorable Acting Chief Justice of the Delhi High Court, Manoj Chetan Sharma, my friend, ASG, Delhi High Court, Mohit Pathur, my friend, President Delhi Bar Association, Mr. Vikrant Yadav, Neeraj Ji, Gupta Ji, distinguished members of the bar, friends, ladies and gentlemen. Mine is not a keynote address. It's not even a keynote. It's not even a key address. But because I have to catch a flight, I have been given precedence. So please don't think that by any chance that I'm the premier speaker. The main speakers are Honorable Minister and the Honorable Acting Chief Justice, and the rest of us are all the supporting cast, including me. Now, this is a subject which I've written articles, been asked to speak on a number of symposiums. It's a subject on which I've had an early association. During COVID in 2020, the Home Ministry constituted a panel, a committee for this reform of the 3 criminal statutes. And we had a chairman, some members, there was an academic, Professor Bajpai, who chaired it. Many students participated. And we were given a mandate to finish it within a particular period of time. Thanks to COVID, I think we finished it even prior to the time schedule that was given to us, and we submitted our recommendations to the Home Ministry for the consideration of the various heads of ED, CBI, so on and so forth, because obviously being lawyers, and most of us defense lawyers, and students who are liberal in attitude, it was expected that we'd be very reformist and liberal in the provisions, and so they wanted it to be diluted by the various agency chiefs. And to some extent, that's what's happened. It's a happy mixture of liberal lawyers looking at it from the perspective of from human rights, etc., and the security of the state and the interests of the state by the various agencies. Now, first of all, one thing was unanimous by everybody who participated, including stakeholders who came for these committee meetings. Subsequently, they came before the Home Ministry and its officials as well. And one thing was unanimous, that these laws were indeed colonial. They were of great antiquity. The Indian Penal Code was of 1860. The Criminal Procedure Code was of 1898 and then amended in 1973. And of course, the Indian Evidence Act was of 1870. So these required, in any event, they were outdated. And it is really surprising. If you look at some of the provisions that remained in the statute book, it is really surprising that these colonial provisions were allowed to stand. They should have been looked at long time back, except for the Criminal Procedure Code, which really did not bring in sweeping reforms, the 1973 Criminal Procedure Code. But there have now been, I might say, right, and this might be a little bit of lack of humility on my part since we started it all in the Criminal Law Reform Committee, that there have been fairly sweeping changes made, and changes which were in the right direction and changes which were needed to break with our colonial past. Now, since there's a paucity of time, very briefly, I'll give an overview of the 3 statutes. What was colonial and what is emerging India. First, there is the Bharatiya Nyaya Sanhita, which replaces the Indian Penal Code. Now, this act was amended a few times, the old Indian Penal Code, since independence. But the amendments were mostly formal. For instance, offences by public servants were removed from a particular chapter. Sections 161 and 165 of the old Indian Penal Code. And all these sections were put under the Prevention of Corruption Act. So they were removed, these corruption offences were removed from the Penal Code, and a new act dealing specially with corruption by public servants was enacted. A second type of change which was brought about was basically a knee-jerk reaction to events that took place in this country. So when we had the horrendous Nirbhaya episode in 2013, I believe it was, we had the provisions under the Nirbhaya Act, and a lot of the sections of the IPC were amended. The sections pertaining to rape, and new sections were added, voyeurism. We're all familiar with those that came in post Nirbhaya. So it was a knee-jerk reaction. How effective it has been is for present and future generations to decide whether the new teeth given to the law has effectively provided the deterrent. But my own personal view is that replacing laws is one thing, but attitudinal change, patriarchal attitudes in particular, need to change before offenses of sexual offenses and the like can really be eradicated from the country. But that's another subject. Now, what was it about the existing Indian Penal Code which needed replacement? Sedition. Sedition, so there's a strong thrust in the Indian Penal Code or the new Bharatiya Nyaya Sanhita. There's a strong thrust towards security of the state. That is the first feature. Now, sedition, for instance, was a purely colonial law, as defined. 124A was a purely colonial law, and it was meant to protect the colonial regime. The statute 124A basically punished disaffection with the government by law established. Now, this was basically an act meant to protect colonial rulers from its colonial subject. So when modern India got independence, 124A was often invoked when you had seditious writing. And people used to say, but this is a colonial law because it's meant to protect the government. It doesn't protect India, it protects the government. So the sedition law was basically, the wording of the sedition law was basically meant to protect, as I said, the colonial masters of that time from any sedition by their colonial subjects. The new sedition law has made a very significant change. The Sanhita now seeks to remove this anomaly with new section 152. It eschews the word sedition. Sedition doesn't exist in the Sanhita anymore. But it talks about, the offense talks about any act endangering the sovereignty, unity, and integrity of India. The section imposes a life sentence of imprisonment or imprisonment up to 7 years and a fine for anyone who by written or spoken words excites or attempts to excite. Now, there are very clear actions which are punishable under the section. It's not vague disaffection. The word disaffection is no longer used. The word is excites or attempts to excite secession, which means breaking away, or endangers the sovereignty, or subversive activities, or encourages feelings of separatist activities, or endangers the sovereignty or unity of India. So, the words brings into hatred or contempt or excites disaffection towards the government established by law in India, which was under section 124A, has been dispensed with, and now we are not concerned with the government of the day, we are concerned with the security of the Indian state. And that is a very significant change. It is a marked departure from colonial legislation enacted for the benefit of colonial masters to independent Indian legislation enacted for the protection of the Indian state at large from fissurous tendencies and subversion by external enemies such as the ISI, the People's Liberation Army of China, and so on and so forth. So that's the first one. 124A replaced by section 152 of the Sanhita. Now a very significant change. Abetting murder in India and abroad. 2 old colonial relics from the IPC have been totally removed. 108A of the old code had been replaced. Now what did 108 say? The old illustration, the title of the section was Abatement in India of Offences Outside India. So, the old illustration read like this. A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abetting murder. Now, ex facie, this illustration, ex facie, considered Goa not to be a part of India. A person in Goa who was abetting a murder in India was considered to be a foreigner. Now, obviously, this was an 1860 statute. It was a Macaulay time statute. But subsequent governments in India since 1947 continued to keep this anomaly on the statute books, in spite of the fact that Goa obtained liberation in December 1961. So, right up till the enactment of the Sanhita, Goa, as per the IPC, was not a part of India. Now, this was a staggering neglect by all governments which previously continued to have this anomaly. Then, another colonial legacy consigned to the dustbins of history is affected by Section 48 of the Sanhita. It creates the offence of abetment outside India for an offence in India. This is the reverse side of the coin. Now, the illustration to Section 48 makes it clear why the acts prescribed as an offence by Section 48 did not find favour with the British. Right? Because if you could punish in India abetment outside India, the entire British colonial regime would be liable subsequently for punishment of acts, General Dyer, etc., all those heinous colonial acts which were committed in India, they would be punishable. So there was no corresponding section to what is now incorporated as Section 48 of the Sanhita. So, Section 48 of the Sanhita makes a person outside India liable to be tried and punished in India for abetting offences in India. This did not suit the British colonial masters, as any Britisher, if 48 existed, could have been tried in India. It didn't suit them. So, most significantly, the illustration to Section 48 would permit the Indian government now to try and punish the masterminds behind terrorist offences in India. The aim of Section 48, and I'll just give you the illustration. Illustration to Section 48 now reads, A in country X instigates B to commit a murder in India. A is guilty of abetting murder. So the aim of Section 48 is to facilitate the trial and punishment of people like Hafiz Saeed within India. Hafiz Saeed, Sajid Mir of the Lakshmar-e-Toiba jihadist group, and of course, the now very infamous Gurpatman Singh Panun of the separatist Khalistan movement. Now, all these, as you can see, are geared towards enhancing and protecting the security of the state. Now, there are others, briefly. States like Maharashtra have witnessed a rash of crime syndicates committing crimes like kidnapping, extortion, robbery, contract killing, and the like. So Maharashtra enacted the Maharashtra Control of Organized Crime Act in 1999, containing stringent provisions against persons arrested and charged, particularly pertaining to bail and burden of proof. Now, it was found by the Union that these kind of activities, criminal syndicates, were taking place across the length and breadth of the country. So a statute like Makoka was required, and Section 111 punishes organized crime, just like Makoka does. So also Section 113 of the Sanhita defines and punishes terrorist acts. So again, the emphasis you can see is securing the integrity and security of the Indian state. These two provisions, like the abetment sections, like the sedition section, are all meant for the laudable aim of guaranteeing the protection of the Indian state. Now, a question will probably arise in future, but the Act it finds a solution in itself. That when there is a terrorist offence committed, will the NIA take it over, or will the local police, the police officer, an officer not below the superintendent of police, who will investigate these offences? The Sanhita says that this will be an officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the Unlawful Activities Prevention Act 1967. Presumably, this is not spelled out in the Act, but presumably, if the terrorist activity is of a cross-border kind, or it is all over India, if it's a crime which resounds all over India, then the NIA will be called, and the superintendent of police will make that call and transfer the investigation which he has discovered to the NIA. Otherwise, if it's a localized terrorist act, then he will act on his own. Another theme which runs through the Act is women's empowerment. In line with Prime Minister Modi's declaration of Nari Shakti, first expressed in the 106th Amendment, the Women's Reservation Bill, and it finds further impetus in the Sanhita. Now, the Indian Penal Code, profuse with Victorian morality, right? They combined all the offences against women, right? They had the offences outraging modesty, sexual harassment, etc., right? And these were all to be found in chapter 16 of the code, dealing with offences under the human body. They were grouped together with offences such as murder, suicide, culpable homicide, causing death by negligence, and so on. Even within chapter 16, offences against women were subsumed under a chapter titled of criminal force and assault. Now, so in other words, the IPC did not recognize that there was a genre of offences distinct to women. The Sanhita, on the other hand, devotes the entirety of chapter 5 to offences against women and children. The Sanhita recognizes women and children as a distinct category of victims who are subjected to degrading and unspeakable crimes. It accepts that their investigation and trial of these offences require sensitive procedural safeguards and enhanced punishment. Now, another very common offence which the Sanhita seeks, and it will sort of, ring a bell in more current times. For the offence of causing death by any rash or negligence, a deterrent, it used to be 2 years, it was 304A. 304A was punishable with 2 years. So for car accidents, rash and negligent driving, the Porsche case comes to mind recently. Investigators used to struggle to bring higher punishment. So rash and negligent driving, which the maximum punishment was for 2 years, they used to invoke section 304, culpable homicide not amounting to murder. Now the mens rea of that section required either intention or knowledge. Right? Now somebody who embarks upon a rash and negligent act neither intends it to happen, nor does he have knowledge it is going to happen. It may happen. He is negligent. So the mens rea under 304 ill applied to an offence of rash and negligent driving which caused death. Now, to overcome that anomaly, no longer will we have to strain the law and the wording of the law and apply 304, but now the new section, 356(2), the new section under the Sanhita now punishes rash or negligent act by a deterrent punishment of up to 5 years and a fine. So there's an enhanced punishment for this now, and 304 will no longer have to be unnecessarily invoked. Now, the Sanhita also introduces a new punishment, community service. It prescribes it for a few petty offences, including the offence of defamation. So now defamation can be punished under 356(2) of the Sanhita with community service. Rahul Gandhi can breathe easy. IPC imposed finances as a punishment the IPC imposed finances as a punishment, be it the entire penalty or as an alternative or an addition to imprisonment. Now, these had not been increased, the fine part, since the inception of the IPC in 1860. Thus, the fine for voluntarily causing pain extended to a maximum of 1,000 rupees. Sanhita has enhanced this fine to a maximum of 10,000 rupees. Section 338 of the IPC punished human endangerment resulting in grievous injury to others with a fine of 1,000 rupees. The Sanhita likewise enhances the fine to 10,000 rupees. Now, in like vein, fines unchanged since 1860 in 81 other offences since 1860 have now been appropriately enhanced by the Sanhita. So gone are colonial punishments and the upgraded punishments have come into force. One last word of the Sanhita. Admirably, the Sanhita eschews the words, and this is very important, because we are now an inclusive society, we need to be sensitive. The Sanhita eschews the use of offensive and pejorative terms which were peculiar to a colonial age. Words like lunatic, insane, and idiot. I didn't realize this, but there is one section which actually uses the word idiot in the IPC. I've never invoked it or used it, so I had the good fortune of not knowing that we had that insensitive word. So, sections 89 in the general exceptions chapter contains the heading, act done in good faith for the benefit of child or insane person by consent of guardian. Section 27 of the Sanhita replaces the word insane person with the more benign expression person of unsound mind. Section 305, which deals with the abatement of suicide of child or insane person, uses the terms insane person and idiot. It is in 305. The corresponding new section omits these and uses again the expression persons of unsound mind. So, in short, the IPC was wholly out of touch with independent India's needs and changing circumstances. And the Sanhita, now a much more widespread, effective, and humane statute, has replaced it by a statute more appropriate to Indian law. So, gone are colonial laws, enter laws for independent India. Now I could go on, but there's paucity of time. Now just a quick summarize on the other two statutes. Just a very quick word, and then I'll end. There are much more illustrious speakers than me, so I'm going to yield as soon as I can. The Bharatiya Nagrik Suraksha Sanhita, which replaces the Criminal Procedure Code, it's worth those criminal practitioners who are in court every day should read each of these sections, because there's a twofold feature here. What is highlighted in this statute are two things. One is technology is used in almost every field of investigation and trial. That's one. The second is timelines are set for almost every stage of the criminal justice system. So there are timelines for completion of investigation. There are timelines for further investigation. All 90 days. You now can't interminably say further investigation and keep an accused in jail under 173(8). We have to put in timelines for discharge, filing discharge applications, disposing of discharge applications, trials. We have timelines for judgments by every court. So at every stage, the emphasis is on speedy delivery of justice, using methods to enhance investigation techniques through technology. For one example, the entire search and seizure procedure now, has to be now mandatorily, it has to be put on audio and video. It has to be video recording. From start to finish, the admissible part of search and seizure will not be punch numbers, but it will be that recording. So gone are the days for police dishonesty in getting professional punches who sign punch numbers later on. That's gone. and gone are drug planting cases. No longer can you plant drugs. And this has happened in narcotics cases. No longer can a narcotics squad play any mischief and plant drugs on anybody, because the entire procedure from start to finish has to be kept on audio and video. There are many, many other provisions, but for paucity of time, as I said, I will desist from saying any more. There's fairly little. Fortunately, the Indian Evidence Act has not been tampered with much, except for the fact that electronic evidence has now been permitted, right, which it should be. But the passage of time has proved that the Evidence Act actually is time-tested and serves the interests of justice well. The only thing perhaps that has happened is that, again, under the Evidence Act, certain pejorative terms have gone. Not really pejorative terms. So in the Bharatiya Saksha Adhiniyam, which replaced the Indian Evidence Act, just two things. What is the departure from the colonial era? Words like Parliament of the United Kingdom, I don't know why we still had to refer to it right up to 2024. Parliament of United Kingdom, Provincial Act, notification by Crown Representative, London Gazette, any dominion, colony or possession of His or Her Majesty. Jury, Lahore, United Kingdom of Great Britain and Ireland, Commonwealth, Her Majesty, or by the Privy Council, Majesty's government, copies or extracts contained in the London Gazette or purporting to be printed by the Queen's printer, possession of the British Crown, Court of Justice in England, Her Majesty's dominions, which we once part of, barrister, have thus been deleted and they are no longer relevant. And we are all advocates now, finally. Gone are the words like vakil, pleader, and barrister. They're out. So, welcome to independent India and goodbye to colonial legislation. Ladies and gentlemen, thank you very much. Jai Hind.